important stuff, so I do want to get it across. When you're in Oregon and you have multiple animals in the same criminal episode that are subjected to criminal treatment, either lack of minimum care or abusive treatment, you can get multiple convictions. This came about in a complicated fashion through the courts of appeals and the Supreme Court, but it is definitive at this point that animals are victims. So what that means is if you have 10 convictions, a person's going to get 10 convictions entered against them. This is important for purposes of trying to get crimes expunged. It's important for trying to get consecutive sentences. It is important for honoring the actual victims of these crimes. So, but in order to do that, we need to have animals individually identified, and we need to have proof, again, beyond a reasonable doubt, that each individual animal was subjected to criminal treatment. It also applies in cases of possession ban violations. This is my big plug here. We hear a lot in animal cases about warrantless searches and seizures. My advice to y'all is get a warrant. If you're not a person who can apply for a warrant, get somebody who can apply for a warrant. Get them to apply for a warrant. It is so important that it's enshrined in both the Oregon Constitution and the US Constitution that law enforcement, the government, should not be searching and should not be seizing without a warrant. So please, please, and know that if you call me, my first advice is going to be get a warrant. The other thing about this that's important to know is you need to know, for purposes later on, if you didn't get a warrant, how long it would have taken you to get a warrant. So use some of these cases where it's bad, but it's not causing death and injury bad, to practice how long it takes you to contact law enforcement and get them to write a warrant and get them to do this thing and that thing. If you don't know, talk to officers who apply for warrants, because there are some counties where you can do them pretty damn quick these days. They do telephonic warrants, which means that an officer chats on the phone with the judge for a while, and then bada bing, bada boom, they have an electronic warrant. And if you don't know that information, it's going to make it really hard at the hearing to prove that you didn't have the time or the resources to get the warrant. Warranted searches, they do take longer to get ready and to execute. So if you're talking about an animal dying at your feet, then that's probably not the best option. But if you get a warrant, then that means at the hearing, the defense attorney is going to have to prove that there was something wrong with the warrant. They're going to have to prove that the warrant was unreasonable. They are presumed to be reasonable searches. You get explicit permission in the warrant from a judge to seize animals, to test animal byproducts, to seize all the things that you can see. When you get a warrant, you can talk about getting paperwork. And getting paperwork means looking into drawers. And looking into drawers means finding guns, means finding drugs, means finding all kinds of other things that you can then charge a person for. And it's based on probable cause. You set out the probable cause, the judge agrees, you get your warrant. You get all that permission. If you go in without a warrant, you do it right away, right? Because it's an emergency situation, it's an exigency, you have to do it right away. So you do it right away and you get that evidence right away. But then you get to your hearing on whether the evidence is going to be let in or suppressed. And the judge turns to me, the prosecutor, and says, why did your agents feel that they had to do this? What's their excuse for violating the Oregon and the federal Constitution? And it is presumed that it was an unreasonable search. So the prosecution has the burden of convincing the judge, no, actually here's all the reasons why we had to do it right away. And that's going to depend on testimony from you about why that was essential, because the prosecutor generally wasn't there, Even if you do see the items and seize them, is testing legal? If you're there seizing things and you open a drawer, whoops, that's not part of the warrant, or that's not part of the search. It's not part of a search or a seizure to get a horse to open a drawer. So if you got something out of the drawer, I don't know if that's coming in. Also, it's got to be based on probable cause plus additional elements, which we will talk about here. I want to be real clear with the people in this room that the Court of Appeals has sent us, in the last few weeks, a strong signal in the footnote of the case from Multnomah County that you are not going to be able to rely on the exigency exception unless you can show that an animal is suffering or basically right on the edge of suffering. Here's what happened. Multnomah County, woman brought her cat to Dove Lewis, and the cat had bones showing on its arm. It had like pretty severe, what looked like burns to the vet. And the vet said, well, we got to do some graft, we got to do some procedures. And the woman said, no, I'm not going to do any of that. And the vet was like, please, can you at least give them these painkillers and antibiotics? And she said, all right, I'll take those. The vet was so alarmed that she called Animal Services. The Animal Services went out, did a knock and talk, and saw what the vet had seen, which is that this animal was clearly, at the time, suffering a serious physical injury and in risk of declining because this person was not doing what they were supposed to do from a veterinary standpoint. Now, the Court of Appeals did say the seizure, the warrantless seizure in that case was justified by exigency. But the judge on the Court of Appeals dropped a footnote and said, while not presently before us, there may be situations where an animal is subjected to an unlawful standard of care. Now think about what we talked about in terms of minimum care standards, but animals looking okay. That does not present a near-term danger of the outcomes prohibited by the animal welfare laws. What are the outcomes? Serious physical injury, death, right? In that scenario, and this is Court of Appeals. I'm married to a Court of Appeals judge, so I'm allowed to talk some smack about them. They sometimes like to drop these little hints in there. This is not binding law. This is what we call dicta, which means that it's just sort of a suggestion about the way the law could go. In that scenario, it may be doubtful that a sufficient exigency would exist to justify a warrantless state action. I think what this is suggesting, and I think this is what the Court of Appeals would do, if you bring them a case where minimum care standards are not being met, but animals are not, dead on their feet, like our horses from Fessenden, they're going to say that's not exigency. Even if you can say, well, there's evidence potentially being lost, what they're worried about is animals actually physically suffering at the time. So, the other thing that means is, while you might be able to, without a warrant, seize the animals that are suffering in that way, please go get a warrant for any other animals that you think you need, right? And this is the other reason why you need to know how long it's going to take you to get a warrant. Because if you can do the math in your head and say, the length of time for us to get a warrant versus what I see as the decline of these animals isn't going to add up. They're going to be suffering serious physical injury or death before I can do it. Then you'll be able to justify going in without a warrant, but not without that. This is 3 weeks ago that this opinion came out. So this is hot off the presses. The other exception, which still is existing, but the Court of Appeals specifically said in this State versus She case at the top, they said that this was not an emergency aid exception case, is again going to depend on the witnesses to the situation being able to testify that the animals have suffered or are imminently threatened with suffering serious physical injury or cruel death, to say that they went in on an emergency aid basis. That's a pretty high burden, pretty high standard. We had it, I think, in Fessenden, and we could have it in other cases. We probably had it in this case, but the Court of Appeals decided it on exigency, so they didn't need to go into emergency aid. Okay. Oh, and there's the vet icon again, because again, if you're working alongside a veterinarian who's telling you this is a case where there's a near-term danger of physical injury or death, then you can rely on that a lot more. But if you're just winging it on your own, good luck, because you're going to have to present your own expertise, your own background, all the information that you have personally. Okay, I do have another slideshow presentation. I'm around all day, so please feel free to flag me down anytime. This one is about preparing for trial, which is going to be our focus for the rest of the day, I think, and is a very important thing that I know a lot of you don't have a ton of experience with, actually going into court. I was actually just looking at it, my calendar is, it's over a year since my last trial, so that gives you an idea of how COVID has slowed things down. I've been in court plenty, but actual trials, especially in animal cruelty cases, are getting bumped to the end of the line. Earlier in COVID, we were doing a lot of deals that we wouldn't necessarily have done to try to get people in and done, because otherwise we just lose these cases because they take too long to get to trial.
Could there ever be a situation, and would it apply if an animal control officer goes in, sees a situation, something's dying in the moment, so takes the animal, but while in there, visually sees other stuff that they know they can't touch or take, could they go back and say, you know what, we need a warrant to go back in there, there's other stuff going on?
Yeah, so that would be my preference. There's a lot of circumstances where if you're in a place where you're otherwise legally allowed to be as a law enforcement agent, and you see, you know, you're not required to just turn your head away from the crack pipe that's on the ground in front of you or something like that, yeah. It's gonna, the hinge in terms of if you do it without a warrant is going to be, were you legally allowed to be in that spot? So again, if you open the drawer, probably weren't allowed to do that, you know, as a law enforcement officer, so anything you see in there, you're gonna have to go get a warrant for. The other thing that occurs to me is sometimes, you know, if law enforcement's taking somebody into custody, they'll take a backpack, and a lot of times, we're gonna advise you get a warrant before you open that backpack, you know? And you have to have some independent basis for needing to open the backpack. Yeah, it's complicated. I would agree with that.
But it is something that could and should.
Yeah, and so the main thing that I want to impress upon y'all is if you're doing a warrantless seizure for an animal that is in that category, and there's 16 other animals which are of varying degrees of care, go get a warrant for the other animals. You know, take care of the one that you need to take care of right away, and then go get a warrant. You can, you know, you can station an officer at the property to say, like, you know, don't take these animals off the property, or if you do, you know, follow them where they're going, but go get a warrant, please. Please get a warrant. I'll help you, I'll write it for you. I won't write it for you, but I'll give you feedback on it. There are a lot of people in this room who can tell me that I've gone over their language for warrants and made adjustments and edits and suggestions, and those go over well, I think, with judges.
Thank you.
Okay, so what is a trial? It's you know, it's kind of entertaining if you're not in the hot seat, but generally speaking, like as a broad overview, a trial is where, in a criminal case, is where a prosecutor, me, tries to prove, beyond a reasonable doubt, to a fact finder, either a judge or a jury, that a particular defendant committed a particular crime in a particular way. Now, while I'm doing my job trying to prove that, defense attorney is going to be fighting for their client, their client's rights, their client's freedoms, fighting against the proof and fighting for reasonable doubt. The judge is generally just going to be deciding questions of law and procedure, how this case goes, what the fact finder is allowed to consider and not allowed to consider. And a fact finder, either a jury or a judge, actually decides what happened. They get all the information, they get all the instructions, and then they decide yes or no, this person is guilty of the crime. Prosecutor, like me, represents the government in a criminal trial. It doesn't matter, it's always gonna be a government on one side of a prosecution. It's gonna be either a state, the federal government, city, county prosecuting. In Oregon, prosecutions for state offenses are handled by the 36 county district attorneys, who may have deputy district attorneys who actually take the cases to trial. In some counties, the actual DA ends up in trial, either because they're the only person in the office or because they have a relatively small office. Prosecutors are fungible. What do I mean by that? I mean that the court system does not care which particular prosecutor is appearing in front of them on which particular case. And a lot of times what the court will say, especially in more populated counties, is, I don't care that this case's original prosecutor is tied up doing something in another courtroom. We're here for trial today, Mr. DA. Send one of your other deputies down to try this case. And what that can mean, and what that certainly did mean in Multnomah County a lot of times, is that you would be walking in to question a jury about their qualifications, having just been handed the file to the case. You know, your witnesses are in the hallway, here's the police reports, read them while the defense attorney is questioning the jury. So that can happen, and as you can imagine, that can sometimes make it difficult to get your case across, and it can also lead to a sense that maybe the individual prosecutor that's trying your case doesn't care about your case because they were just thrown into it. You know, in some senses, that's what we live for. That's why we're doing the job, is to get these cases and get them to trial and get them done. But the system is such that they treat us as replaceable objects. Prosecutors are not your lawyer, including me. I am not your lawyer. Your lawyer is a person that can give you specific legal advice. Do this, don't do this. Person that can say, that can stand up and can defend you. A person that you can talk to privately and cannot then later on be forced to tell anybody what it is that you talked about. Lawyer-client confidentiality. We don't have lawyer-client confidentiality, and the chances are that if you're talking to me about a case that I'm prosecuting, the information that you convey to me, unless it is included somewhere else in information that the defense attorney has, I'm gonna take notes, I'm gonna write something down, and I'm gonna send that information to the defense attorney. So if you have something secret to tell me, please don't. Please don't. Don't have secrets. Let's not have secrets between us, but like, if there's something that you're worried about, criminal liability or civil liability, I'm not your guy. I'm not your first guy. You all work for agencies that either have legal representation by virtue of the fact that you work for a county and you have a county council, or can get legal representation. If you work for a humane society, I'm certain that your agency has had reason to consult with an attorney at some point, and they may have one on retainer, they may, have one that just helps them out on a pro bono basis. Don't know what it is. It's not me. And prosecutors, with a few notable exceptions, do not specialize in animal cruelty. So they don't know a BCS from BAC. They're not going to be able to, confidently necessarily step into these cases. Now, prosecutors do have a ton of experience in the courtroom, generally. They get going, they get trials, COVID notwithstanding. So they will be able to talk you through trial procedure, but you may have to, at the same time, be educating them about the animal science, the animal care of it all. Judges are gatekeepers of the evidence, which basically means they decide what evidence is legal for the fact finder to consider. So this is where motions to suppress come in. Defense attorney says, They seized that evidence unlawfully. Judge, therefore, you shouldn't allow the jury to consider it. Now, a motion to suppress can be for some or all of the evidence. And there are a lot of situations where some evidence gets suppressed, but not all of it. And it's enough, there's enough evidence left that a prosecutor is going to go forward with the case. The important thing to know in that situation, if you are a witness, is did anything I did get suppressed? Anything I collected, or any information that I know is out of bounds for this particular trial? Because if you don't know that, and you get up on the stand, and you're answering a question, and you say something that a judge has already said is out of bounds, that could be grounds for a mistrial. The defense attorney is definitely going to object loudly and clearly, and it's going to make you look silly and unprepared in front of the jury. So before you testify, is anything that I know about this case going to be out of bounds? And one very common thing that, if you and I are talking about a case, you're going to tell me every horrible thing you know about this defendant. He has DV convictions, he's behind on his rent payments, he drove through a red light the other day. The only thing that the judge is going to care about in your criminal case, and the only thing that they're going to let get to the jury, is information that implicates their behavior as to the particular crime. So if you get up on the stand and you're talking out of school about stuff that this guy did before, stuff that he has in his criminal past, you're going to get in trouble. Sentencing is often, I say often here because there are some situations not applicable to animal cruelty crimes where sentencing is taken out of judges' hands. Mandatory minimums, there are no animal-related mandatory minimum statutes in Oregon. So for animal cruelty cases, sentencing is always entirely left to the judge's discretion. And in the courtroom, the judge is in charge, and in my house, frankly, but we'll talk about that later. If the judge makes a ruling, if the judge suggests that you should do something in a certain way, you disobey them at your peril. Remember that the power that the judge has in these cases is often completely absolute. There's a stage of every trial, criminal trial, where the defense attorney asks the judge to grant their client a judgment of acquittal based on the fact that the state hasn't proven its case. This typically happens before the defense even gets up and puts on their case. It's after the state's done, but before the defense has started. A judge at that moment has the ability to acquit the defendant. And there's nothing that the state can do to get that case back. There's no appeal that can be filed. There's no pleading, begging that can work. The judge decides at that moment, for any reason, to acquit a defendant, they can just go ahead and do it. So again, the judge is in charge. The other thing that the judge has, and I hope you never even have to think about this, is what's called contempt power. If you do something in their courtroom or related to their case outside of their courtroom, and they think that that is in violation of something that they have handed down, in violation of a rule of their courtroom, they can throw you in jail, or they can give you a fine, just right away. Now, you can't appeal that, but who wants to spend a couple nights in jail to figure that out? So remember, the judge is in charge. You may disagree with them vehemently. Don't test them. I don't suggest that you test them. Yes?
Does that happen if, like, say, I know in our county, if it's a felony, it has to go through grand jury first?
Yeah.
And then the grand jury decides whether they feel like the state has enough evidence to move forward, and then they either acquit or say no.
Yeah.
If that happens and it goes in a courtroom, is it likely that a judge would do something of that nature? I mean, they still have the right, I'm assuming, to do that since even though it went through grand jury.
Yeah, it's a different situation. So remember, in grand jury, what the grand jurors instructed is, did the state present enough evidence, assuming no rebuttal or any kind of input from the defense or any kind of excuse raised by the defendant to sustain a conviction. right? And we talk a lot about grand juries as prosecutors, and it is true that grand juries tend to go along with what the prosecutor recommends in an extreme degree. And certainly when a judge is considering a motion for judgment of acquittal, what they're supposed to consider is whether the facts put on by the state could sustain a conviction at that stage. And there are situations where a judge rightly says something wasn't proven here. Because remember that trial is also a totally separate proceeding from grand jury. So the judge isn't considering that. So you can have witnesses drop off, you can have evidence disappear or go bad, or you could just have an incompetent prosecutor that doesn't put on the evidence that they need to. And then the judge says, I didn't hear evidence of serious physical injury here, so acquitted. But what I'm sort of suggesting to you is that a judge can do that for any reason whatsoever. So stay on their good side, yeah? Judges are very honorable people, and I love them very much. So, the fact finder in a case is usually going to be a juror. The thing to remember about jurors is that they are members of your community. Judges are also members of your community. So when you're talking to them, you should be relating to them as members of the same community. If you come in there with a theory about why this was animal abuse or why this was animal neglect that is totally out of whack with what people in your community think, you can expect that they are going to look at that skeptically. You can expect that they are not going to take you seriously. So that means, fortunately or unfortunately, an animal abuse case that might fly in Multnomah County may not get traction in Union County, may not get traction in Curry County. I don't know. But just be aware of your surroundings, be in your community, be of your community. This also implies that if your agency has less than stellar reputation in your community, you may have trouble convincing a jury. So every time that you're doing any kind of work, be aware that you're going to have to stand up in front of members of this community, and you're going to have to convince them beyond a reasonable doubt that what you're saying is the truth. The defendant is faced with significant challenges, and the defendant has significant rights in a criminal justice system. And the fact is that much of the criminal justice system is designed to protect defendants' rights because the challenges that they face are so high. And I understand that we're talking about some unsympathetic people here, but let's consider for a minute. And we've all known people who've gone through the criminal justice system in our personal lives, not necessarily for animal cruelty, but maybe for a DUI, maybe for disorderly conduct, something of that nature, maybe for something more serious. Defendant has been publicly accused of a crime. In many circumstances, their mugshot has been published. That no longer means that their mugshot showed up in the newspaper one day and then everybody forgot about it and moved on. That means that for the next while, if you search their name online, one of these mugshot websites is going to come up. If you search their name on Facebook, people are going to be talking about this crime. There is intense social media backlash in these cases against these defendants, rightly or not, but remember the kind of rhetoric that I'm talking about. People are calling for executions. People are calling for years of imprisonment. People are calling for serious bodily harm. The one thing that I've seen most often, and I'm sure you guys have seen this too, the same thing that they did to those animals should be done to them. These are people we're talking about, right? It's never anybody's choice to be arrested. What I mean is, nobody ever plans, oh, I'm gonna commit this crime up until this day, and then I'm gonna get arrested, and then I'm gonna deal with that part of my life. So you're caught off guard instantly. Criminal defense, even if you have a public defender, is expensive. And what I mean by expensive is, you have to take time to deal with your case. And time, as we know, is money. So you're gonna be either getting babysitters, taking time off of work, finding coverage for other things that you need. You're going to be dealing with this case, even if you get a free public defender. You may also be held in custody or have other restrictions pre-trial. You may, in a lot of these situations, and I say this to jurors in my cases, These can be animals that these people truly believe that they love, and they are taken away from them. They're taken away from them, they do not have that companionship anymore. And we all look at those animals and say, this is horrible what this person has done to this animal. But remember, as soon as that animal is taken away, they no longer have that companionship that they felt that they had. And we're gonna try to hold them to account for that. We're gonna try to hold them, keep those animals away from them for the rest of their lives. But you have to understand and get inside the psychology of the person that you're prosecuting, that you're investigating, or you're never gonna understand this system. So, what kind of rights are we talking about? Innocent until proven guilty. That doesn't mean that you have to have any doubts about their guilt. But what that means is the system has to treat them as innocent unless and until the state puts on that case beyond a reasonable doubt and an independent fact finder, a judge or a jury, finds them guilty. They have a right to an attorney, or they have a right to represent themselves if they want to. They have a right to a speedy and public trial. They have a right to confront witnesses, which we'll talk about in a minute. And they have the right to remain silent, including at trial and before trial. So if they say to you, I don't want to talk about this, I want a lawyer, we're done talking, understand that's their right. The burden of proof and the burden of production means putting evidence forward is all on the state. If we miss something, if we don't have something, that's going to be held against us at trial. Defense attorney, Lionel Lentz, represents a defendant, tries to raise that reasonable doubt. They're going to cross-examine you, and they are going to put on their own witnesses. This is their job. Don't take it personally. They're not. And every bit of resentment and anger that you show them is going to be factored into the jurors' minds as to your frame of mind in terms of how you're thinking about this case. So if you get riled up, if you get angry, if you get upset, they're just going to take that as proof that you're biased against their client. And the defense attorney will stand up in their closing argument and say, did you see how angry that animal control officer got with me? That's an agenda. That's their agenda. Don't treat them with indifference. Don't treat them with disdain or hostility. They can be frustrating. I know. I work with a lot of them. But they are doing their job, which they're paid to do, and which, remember, they're required to do under the Constitution in order to guarantee these folks' rights, right? Because we all know people who have needed defense attorneys at one time or another. So understand that the defendant in your case has just as much of a right to a defense as any other person that you've ever known that's gone through the criminal justice system. Witnesses. I've never had Shep the Wonder Dog in my case, but this would be a great witness. There are fact witnesses and there are expert witnesses. The difference is whether or not you'll be allowed to testify about hypothetical situations and testify about your opinions about the case. You should know which one you are, what you're going to be testifying to. Generally speaking, if you're on the ground, observing things with your own eyes, you're going to be a fact witness. If you have some special training and experience in animal care issues, you may be an expert witness. For trial prep, I would say the main step is to figure out who your trial prosecutor is and figure out if you're likely to go to trial. The prosecutor's probably going to go through some pretrial negotiations to try to resolve the case without a trial. But figure out who your trial prosecutor is. Like I said earlier, it may not be the same person that is working on the case at the front end that ends up taking it to trial at the back end. Prosecutors are fungible, so they can be replaced at a moment's notice. There's also a lot of job switching and stuff that happens. People retire all the time. So to the best of your ability, figure out who's going to be taking your case to trial. Figure out if they have any questions for you. If anything is missing from their file in the case that you have. It is the worst feeling when you get a witness on the stand and they start talking about all the pictures they took on their phone of this dog, and you realize you don't have any of those. So make sure that they know everything that you have. If you want, when you're testifying, to refer back to a report that you've written, that is gonna have to be something that you've turned over to the prosecutor in advance. Otherwise, the judge is not gonna let you consider it, because what I do with that report is I send it to the defense attorney so they can have it at the same time. That's required by me, and so that should be required by you. You should ask a trial prosecutor if you're gonna be identifying any exhibits on the stand, what they are, take a look at them. Another bad feeling in court is handing somebody a picture of something and asking, please explain to the court what this is a picture of, and the person taking a look at it and saying, I don't know, a horse? So you're gonna wanna make sure, 90% of the time you're gonna know what they're talking about, but considering these cases can involve a lot of different people taking a lot of different pictures, make sure that you know which ones you're gonna be talking about. And again, have there been any rulings excluding evidence that you know about? Is there anything that I shouldn't talk about in front of the jury? In terms of preparation, every one of you lives in a county where there's a courthouse, and every one of those courthouses has at least one hearing per day. Even just going into the building and sitting in the courtroom and just getting a sense for how court works is effective in preparing for trial. It helps lower your blood pressure in terms of actually being in the building, helps you see how we're all just people doing our jobs, and helps you understand. Best practice is find a trial. And although there's a slowdown for COVID, it's not stopped. Like I said, there's 5 trials scheduled in Jefferson County and Madras in a couple of weeks. So, even if my trial is not going, I expect you to find that other trial and go to it, right? See how it works. Review your reports, go over your reports, figure out if there's anything missing from your end. Again, if you make any written notes on your reports, that's fine, but if it has information that your report didn't have originally, you gotta make a photocopy and get that over to your prosecutor if you wanna rely on that on the stand. Practice, practice, practice. That doesn't have to mean setting up a fake courtroom like we're gonna be doing in a few minutes, but it can mean just telling your friends the story of the case, telling your partners, here's what happened, here's what happened, here's what happened, and in the way that you tell the story, you will learn the rhythms of what happened and how to best express it. Because while you're talking about your case, especially if you're talking to somebody who's not involved in animal services, they're gonna say, what do you mean by that? And you're gonna understand, I have to do a little bit of a better job of explaining what this is to a layperson, because your jury is also gonna generally be people that are not in this world. Day of trial, always check in with the DA's office a day or two before trial, make sure to know where and when to be. Very often the first day of trial is going to be dedicated to jury selection, and you won't even get started until after lunch. So if you don't want to show up extra early and get gold stars, you can check in with them and say, when do you actually need me in the courthouse? Dress professionally, have your own copies of your reports available, be prepared to show up and wait, because things do go wrong and other things do have to happen. There's a million different hearings going on in any courthouse at any given time. Sometimes judges get pulled away, sometimes jurors get pulled away. The most important thing maybe here is to behave yourself in and around the courthouse. You don't know who is involved in your case just by looking at them. Jurors are gonna wear a badge that say juror, but only once they get put on the jury, and only if they remember to put it on. So if you're talking smack about your defendant in the courtroom, in the courthouse, in the parking lot, and there's a defendant's family member, defense attorney investigator, the partner of the defense attorney, law partner, then you can expect to have those comments repeated back to you on cross-examination. Don't talk to the other witnesses about your case. Talk about your kids, talk about your dogs. Don't talk about your case, okay? You've all heard me say it before, right? This is the only thing that I need you absolutely to remember from this presentation. When you're testifying on the stand, you tell the truth. You tell the truth. That's why you take the oath. Truth, whole truth, nothing but the truth. What if a witness lies under oath? Well, there can be personal consequences. It's a crime to lie under oath. In certain circumstances, it's a felony that carries potential prison time. It destroys your credibility. And it can have certification or employment consequences. We've all heard about police officers who've been put on Brady lists and then they're working desk work for the rest of their career, or maybe not being a cop at all. There are also consequences to the case. If a witness lies under oath, there could be a mistrial. Convictions can be overturned later on. Animals, in the worst case scenario, that were abused or neglected could be ordered to be returned to their abuser or neglector because a witness didn't tell the truth. Your agency could also face consequences. So this is not just for you, this is for the people that you work with. Because in a year, a potential juror is not going to remember specifically that it was you that lied under oath. But a juror is going to remember that an agent with the county animal services lied under oath. And they're just going to impute that to any witness that they see from county animal services. There's also going to be media scrutiny. Other agencies can refuse to work with you. The agency can get sued. And agencies can have their certifications terminated or suspended, as the case may be. I really, I hope none of this happens. I just have to stress how dire importance this is. Tell the truth, okay? When you are testifying, there are 3 answers that you can give, if true, that don't necessarily occur to people in the moment. I don't know. If you don't know the answer to a question, please don't try to make it up. Please don't try to guess at what I'm asking you. I understand that I may ask you a question that you don't know the answer to, and I would prefer that you say, I don't know, and allow me have a chance to rephrase the question or figure out a different witness than for you to spout off about something that you're not sure about. I don't remember is also a valid answer. You're going to have your report in front of you. It's going to have specific answers in there. What's going to happen is I will then ask you if that answer, if reading your report would help refresh your memory as to what that answer is. You're going to hopefully tell me yes, and then the court will allow you to look down and read your report. Please don't testify by just reading from your report. It doesn't look good, judges hate it, and it's going to draw an objection from the defense attorney. So if you don't remember some specific bit of information, I don't remember is a perfectly good answer. It's in my report. Okay, then let's take a look at your report. And then the third answer that you can say is, can you repeat the question? Can you rephrase the question? This is particularly important on cross-examination because defense attorneys will play this game where they get into asking multi-part questions with hypotheticals thrown in there and subparts and footnotes, and then they'll ask you to say yes or no at the end of it. So can you rephrase the question? If you don't understand the question, don't try to answer it, right? Because that gets you into trouble too. There is a significant difference between how I'm going to ask you questions on direct examination and a defense attorney is going to ask you questions on what's called cross-examination. My questions are going to be more open-ended, not, isn't it true that? My examples here, how are you employed? Did you go to this location? When did you arrive at the location? What happened next? What happened next? What happened next? They invite narrative answers. Defense attorneys' questions on cross-examination are going to be a little bit different. They're going to be leading questions. Isn't it true that you don't have any veterinary background yourself? Isn't it true that you went to a presentation by noted animal rights activist Jake Kamins and he told you to lie on the stand? Don't argue with him. Again, this gets back to treating defense attorneys as they're doing a job. And always remember that the pattern is this. You get asked questions on direct, then you get asked questions on cross-examination, and then the prosecutor gets a second chance to ask you questions based on the cross-examination questions. So if they trick you into answering a question in a way that you think is harmful, tell the truth, and just understand that the prosecutor is going to ask you a question, something like, when the defense attorney asks you this question on cross-examination, you said yes. Explain a little bit more about why you said yes. Tell us a little bit more about that situation. Like I said, visit the courtroom in advance, know where you're gonna go. It's not a great feeling if you're walking into a courtroom for the first time looking like this. Like which seat do I sit in? That does not install confidence in the jury. Follow the judge's directions and be aware of your surroundings. When you're testifying, don't read directly from your reports, both because it looks like you don't know what you're talking about and because a defense attorney will definitely object. Don't argue with the questions. It's okay to say, it's a little bit more complicated than that, but don't get into a back and forth. And direct your testimony to the fact finder. In other words, when you're answering questions, be talking to the jury. Establish a rapport with the jury. They can't talk back to you, but if you're looking at them and you're going back and forth and talking to them, they are going to trust you a lot more. When you're answering a question, listen to the whole question, pause, and then answer the question. Don't cut the questioners off. Judges hate it. Doesn't matter if they're saying something totally wrong. Wait until they're done. Defense attorney or prosecutor or anybody in the court, I guess, says objection, stop talking. That's your cue to stop talking. I don't care if you're in the middle of a syllable. Stop talking. The reason why is objection is a signal to the judge that something that just was said or something that's about to be said is not allowed. And the judge has to make a decision about that. And judges do not like having to sort out people yelling over each other. The other thing is that here in Oregon, in every criminal state court, we do records by recording the trial first, and then if somebody wants a transcript later, we send it to a transcriptionist who then listens to the recording and types it out. So there's not going to be a live transcriptionist in the courtroom. So if you're talking over the judge talking, over the defense attorney talking, there's just going to be a big jumbled mess on the record, right? So if you hear the word objection, it's going to be annoying, but just stop talking. We can get you back on track, back answering your question. The other thing is that you risk saying something that's not allowed, and then the judge is going to have a real problem. Okay, that's all I had to say about testifying for now.